As the slide says, I'm Elizabeth Shaver. I'm an assistant professor at the University of Akron School of Law. Points to people who know where Akron is. Okay, right? In Ohio. Some would say a suburb of Cleveland, others would say not. I teach courses in education law and special education law. This is my first cadre conference, and I'm really excited to be here. I think that as an academic and a lawyer, I have a slightly different perspective. I'm appreciating hearing all of your perspectives. And so we're going to take a little bit of time today talking about proposals to reform the IDEA's due process structure. I come at this a little bit differently as a lawyer because I'm looking and focused at our federal statute and our federal regulations, and then of course how these statutory provisions are implemented by different states at different levels. I teach a course right now. I'm teaching my special education seminar, and so for my students who are going to be lawyers, I'm very focused on what does the federal statute require, what does it permit, what do the regulations say. So I might be a little bit more of a technician in that regard, okay? So we're really going to start today with a little bit of background, and then I want to get your opinions. One of the things I think it might be valuable to do for a minute when we talk about special education dispute resolution is to actually step back for a minute and think about potential special education disputes. We hear a lot of talk about the IEP process and how that's a process that is ripe for disputes to occur, and I wholeheartedly agree with that. However, it is valuable to think about for a minute that there are disputes that occur in special education that don't involve an IEP. And structure and think about dispute resolution mechanisms that wouldn't involve an IEP, right? So one of the main focuses for potential special education dispute are issues involving evaluation, eligibility, or child find. And none of those involve an IEP. If a child is deemed not to be a child with a disability under IDEA, the school district is not going to proceed to write an IEP for that child, right? Everybody, right? Okay. Of course, we do have a lot of disputes that do focus around an IEP, and those can be the types of disputes that relate anything to a level of service that a child's going to get, placement, whether it's a least restrictive environment issue or a private placement issue, right? Issues about extended school year services, or some of our IEP disputes that we might have. There could be disputes about compensatory education. Mom and dad agreed to the IEP, but the district didn't actually provide the services as required by the IEP, right? So that's not a dispute about what the IEP should contain, right? It's a dispute about whether or not the district actually provided the services. Transportation or related services could be an issue for dispute resolution, and discipline, of course. And I don't mean for this to be exhaustive, but just to step back for a minute and think about those other types of disputes that don't involve the IEP process, okay? In our federal statute, our current due process procedures, there are 4 of them. There's the state complaint procedure, okay? That's a procedure that is not driven by the parties, not driven by the parents or the school district necessarily. So in the realm of due process, we have 3 due process procedures, including our ADR procedures, which would be our resolution session, mediation, or a due process hearing. That's in the federal statute, right? That's in the federal statute. That's all the federal statute requires, the state to develop plans or procedures for these processes, right? What are our other processes that we have that aren't part of the federal statute? IEP facilitation, right. What about some others in specific states? I'm interested. Anybody other than? Solution panels. How would you define what a solution panel is?
It's a group of 2 to 3 people who work with the 2 disputants, usually a district rep and the parent, and it's facilitating conversation between them to compile an agreement.
And is that before or after due process?
Before.
Okay.
To prevent going background.
And what state do you have this solution panel?
Well, we have in California.
In California.
In our SELFA.
Okay. I heard somebody say ombudsman. Yes? Yes? And how would you define that? Huh? So it's in a sense like this, it's sort of somebody sitting down with the parties and
Actually facilitating any number of different processes.
so it,
Yeah, it's taking complaints, figuring out what the best possible, what the best strategy would be, including actually implementing.
right. Okay. Anybody here from Massachusetts? What about your SpedX project, which,
I'm not on the due process, I'm on the process.
okay,
Is that the expedited due process procedures where they do a preliminary hearing, is that what you're talking about?
well, Massachusetts is actually a jurisdiction that has several ADR or dispute resolution options that they've layered on. So they have, if a due process complaint is filed, they can have a advisory opinion from the hearing officer in advance of the actual hearing. They also have something called a settlement conference. They also have something called the SpedX project, which I understand is not getting as much funding. And that is where the parents in the school district in a dispute that involves an IEP could actually agree that a external neutral consultant is going to write the IEP. And the parties, what? You shook your head no?
Well, I don't believe they're still doing it. I think it.
It's
was-
defund, it's not funded
yeah,
anymore.
it's sort of
Right, okay.
Rejected even,
Yeah. Rejected by the parties.
and rejected by the state.
Yeah. So there are these additional things that states have tried, some have been abandoned, right? But this is what we have in our federal statute, okay? This is what we have in our federal statute. So there's another piece about IDEA due process that is important that I'm not sure always gets talked about so much, and that's one tier versus two tier. Who can tell me what the one tier versus a two tier structure is? Yes.
Well, the two-tier structure, well, the one tier, there are two tiers, obviously. The first tier is basically more of an evidentiary type hearing. The second tier serves as almost a panel of review to go over the decision findings of the hearing officer on the first tier. It almost serves as a kind of administrative form of a court of appeals.
Right, it's an administrative appeal, right? So in a one-tier system, the due process complaint is heard by a hearing officer who would issue a decision, and then any aggrieved party can file suit in federal or state court. But in a two-tier system, you have to go through this intermediate system of administrative appeal before you can file in federal or state court. There are 8 states that still have a two-tier system. When Pennsylvania, even before the passage of the EAHCA, in 1975, Pennsylvania had a system for dispute resolution under the Park case. Pennsylvania was the primary architect of a two-tier system, okay? And when the federal statute was first passed, the states could decide whether they wanted a one-tier or a two-tier system for due process at the administrative level. And about half of the states took one-tier and half took two-tier. But over the years, gradually the two-tier system has gone away. We only have 8 states that are left with a two-tier system. Is there anybody here from North Carolina?
I used to live in North
Okay, so if they say it's a modified one-tier system, okay, right, okay.
Goes to an administrative
Appeal, right, yeah. Yeah, so it's even a little funkier than that. So I live in Ohio, we're, what? Funky is the term, right? Is the official legal term for it. I live in Ohio and we have a two-tier system. Now, when we think about due process, dispute resolution and special education disputes, and we want them to happen quickly, right? Right? We want our children to be in an appropriate educational placement. By the way, just so you know, I am the parent. I have a 17-year-old son with autism, so. You want your child to be in an appropriate placement. You don't want to spend time in this process, right? So it's a real fair question whether or not our federal statute should continue to allow states to even have a two-tier system, or whether or not that is a piece that should be eliminated. It's not really a dispute resolution mechanism that gets talked about so much necessarily. Yeah.
I just have a quick question. With dispute resolution right now, even with the one-tier system, I am not seeing due process hearings that come back with a decision in 45 days.
Right.
And so with the two-tier, how much does that extend it out even further? I would think that it did, or is it going to help it?
Right. Well, of course, we know that the federal statute says 45 days, but you get 30 days for your, to resolve the matter ahead of that. So really, it's a 75-day timeline, which never happens, right? Never happens, right? So in a state like Ohio, the appellate process is supposed to take, I'm forgetting off the top of my head, I think it's 30 days, another 30 days, right? But the hearing officer can extend, the appeals officer can extend that as well. And so Ruth Kolker at Ohio State actually did a really good article. She's at the Moritz College of Law in Ohio State about Ohio's dispute resolution, and she looked at due process, and she said on average it takes about 11 months to get an initial hearing officer decision in Ohio, and then you have to go to the second tier as well. So, yeah, right. So, yeah. So either way, what I hear you saying is one-tier systems are not that fast, right? Right. But a two-tier system is even slower. And one of our most active jurisdictions, and anybody here from New York, state of New York? Right. I know Maria's from New Jersey, so I'm not going to. Yeah, right. New York is one of our most active jurisdictions, and one of the jurisdictions where practicing attorneys have just I don't even know what the adjective is. Very strong complaints about the time it takes to get anything, any kind of decision out of the administrative due process procedures in New York. Okay, so the 2004 amendments to IDEA, there were actually several proposals to change or reform IDEA due process, and there was quite a lot of work done. George W. Bush commissioned a task force on excellence in special education in 2001, and that task force wrote a report, and there were several proposals that were floated during the legislative process, if you look at the legislative history. And some of those included eliminating the two-tier system, making mediation mandatory in all special education disputes. That was one of the things that was floated at the time, that the parties would be required to mediate, including IEP facilitation as a dispute resolution mechanism. That was actually in the report, and it was contemplated. And then there was requiring the states to have procedures for voluntary binding arbitration, which would be a hearing before an arbitration panel with no right of appeal, right? So all of those were floated in the time frame, but in the end, Congress made only two changes. One was to add the resolution session, and the other was to allow the parties to mediate a due process mediate a dispute before the filing of a due process complaint. Those were the only two changes in 2004. Okay, so I started taking a look at this, and I started looking at some of the, you guys know about mediation, we don't. The resolution session, right? Everybody understands the resolution session is supposed to take place within 15 days, but it actually adds 30 days, right? You have that 30 days to try and resolve the matter before the 45-day clock starts to run, okay? And that both of those things, the resolution session and mediation, can delay the timeline, although we know that the timeline doesn't work, right? When has anybody ever gotten a hearing officer decision within 45 days, right? Okay, so even that doesn't work. So what are some of the criticisms after the 2004 amendments to IDEA? Advocates for parents and children said it's still too expensive for parents who can't afford to pay attorneys and expert witnesses. They said that IDEA should be amended to allow the recovery of expert witness fees, right? Who's familiar with Schaefer versus Weiss, right? What did the court say in that case? Okay, so the Supreme Court said it looked like Congress wanted to allow a recovery of expert witness fees, but because it wasn't actually written into the statute, we can't allow recovery of expert witness fees in special education disputes, right? Okay. And to clarify provisions regarding awards of attorney's fees to prevailing parties, okay? So a lot of our advocates raise really, really fair questions about whether or not due process is still too expensive. As far as I can see from my research, I don't have any really, I think the last data was like in 2002, but 2/3 of our children, as of the 2002 data, 2/3 of our children who require special education lived in a family that had an income at that time of less than $50,000 a year when the poverty level was $18,100 a year, right? So if you think about due process and the cost of it, whether or not it's just prohibitively expensive for the majority of parents who may be seeking to access it, whether or not there is this divide when due process is filed such that it is available to wealthier, more educated families, that wealth disparity. And so some of our scholars have voiced concerns that the system itself needs this radical overhaul in the sense that it relies on private enforcement, right? It relies on our parents to advocate for their children. And there have been various proposals floated to make special education due process more of a public enforcement mechanism than a private enforcement mechanism. And then we have school administrators and school districts that say that the cost of due process for them is so high that they often cave in and provide services that they really don't believe they are required to provide under IDEA. Okay? So they say that, you know, we need to be mindful of our budget, and rather than spending our money on litigation costs, we will provide this, right? So there's in my view, these very valid concerns about where we're going and what to do. It's also said if you set aside the money, that due process is inherently anti-collaborative, right? And that it poisons the school and parent relationship, right? In a situation where a cooperative relationship is so important, right? So I'm a lawyer by training. I used to be a litigator, right? So I had clients, and you know, when you get in that adversarial relationship, by and large, this is an issue or a problem for my client that is a one-off, right? You entered into a contract, you have a contractual dispute, you don't like the other side, let's settle the matter, move on, or we will continue to litigate. Well, that's not true in this type of relationship, right? If your child is 5 years old and you don't have the financial means to move out of your school district, you have a long-term relationship with your school district. And how are you going to maintain that relationship, even as you, as a parent, are advocating for your child, or as your school district is really putting its best foot forward and there's a genuine disagreement, right? Okay. And then another criticism, mainly from practitioners, our special education attorneys, is that the quality of review by independent hearing officers can vary greatly, right? Depending on the particular individual's training or experience and the process by which the hearing officer is hired and paid. So for example, in Ohio, our hearing officers are independent. They are private practice attorneys. They charge an hourly billable rate to preside over a due process hearing, and they charge their hourly billable rate to write their decision. And we have decisions issued that are about 100 pages long. Yeah.
They don't charge their billing method. They only charge what the state allows them to charge. So they all charge the same.
They charge the same amount. They charge, you're right, I misspoke. They don't charge a fluctuating, but it's an hourly billable rate without a limitation
On hours.
on hours, without a limitation on hours. Thank you, right.
So who pays that? The state, the district, the family?
The district pays it. Yeah, the district pays it.
Question.
Yeah,
Those attorneys, what is their practice otherwise?
they're just private practitioners. They could have, you know, any kind of general practice.
So not necessarily specializing in education.
Right, other than serving as an independent hearing officer for special education disputes, they may not have any other clients or any other matters that,
Pattern of being attorneys for districts. Or,
right. Yeah.
Who assigns the hearing officer for each hearing?
The hearing officer is chosen.
Used to be that they were
Chosen.
Now, they're
There was
just regionally assigned.
regionally assigned. They're assigned by the SEA. They're assigned by the ODE, the Ohio Department of Education, right? The district informs them, right? Used to be chosen by the school district, though. Yeah. Was there another question? I thought I saw another hand up. No? Okay. So here are some of the proposals to amend IDEA due process, right? to have IEP facilitation be in the federal statute. It's not currently part of the federal statute. So states are not required to have a plan for IEP facilitation, right? It's purely voluntary. Voluntary binding arbitration is still a proposal that gets floated. Professor James Rosenfeld wrote an article in 2012 in which he sort of set forth, in which he says in his article, you know, this would need a lot more vetting, but this sort of broad brush proposal for voluntary binding arbitration. That's the kind of arbitration where it would be before an arbitration panel and with no right of appeal, and that the arbitration panel would be very active so that it wouldn't necessarily be driven by the school district and the parents as advocates, but that the panel could ask for witnesses, pose questions, ask for information. So it would have something of a shift from what you might think of as even a normal arbitration or a piece of litigation. Enhancing public enforcement of IDEA has been proposals that have been floated. You know, have any of you seen proposals for every child, eligible child with a disability, to have their own advocate, their own special education advocate, okay? Or something akin to a public defender's office, some sort of public funding for special education advocacy. There are some other proposals. Eloise Pasachoff at Georgetown University wrote an article where she was actually proposing that the federal government create a database of IEPs where the children's name, obviously for privacy reasons, that kind of stuff would be scrubbed away. But the notion was that wealthier and more educated families get better IEPs, and maybe we should have a database of IEPs that's cross-referenced by family income, so that you could see, you know, gee, I have a 17-year-old child with autism, right? I'd like to see what other high school age children with autism have written into their IEPs. It's kind of an interesting proposal, right? You shaking your head no, why?
I was thinking about individualized and, like, you know, I was thinking about kind of the implications and ramifications of shopping for IEP interventions.
That's an excellent point, and actually I sort of agree with that philosophically as well. It removes the individualized, and it could almost lead to a standardized IEP. So if you're a 16-year-old boy with autism reading at a 5th grade level, here's your IEP, right? So there is that point. On the other hand, I am the parent of a 17-year-old child with autism, and I got to tell you, sometimes I'm thinking, I wonder what they get. You know what I mean, right?
Yeah, but how about a manual with evidence-based practice and the evidence?
Okay, so I'm going to add that right here.
One of the things that I see is because of finances, etc., we see IEP formats or forms, and they pull a goal from here, and so it isn't as individualized as I would like to see it happen to be.
Mm-hmm.
And I know that's frustrating to educators and parents a lot.
See, and that's a great point as well, because any parent going into an IEP meeting, even if you get a draft ahead of time, I live in a great school district. I get a draft well ahead and actually have a pre-planning IEP meeting before I have my actual IEP meeting. But I have no way of knowing necessarily if, you know, objective 1.5 is the same on 15 other IEPs in the district, right? As a parent, I have to read it and make my own determination whether or not I think this is an appropriate 12-month goal for my son, given, you know, his present levels and where I want him to go. So, you know, I don't know I have no way of knowing except for my own review, and I think this should be a little bit different to individualize it for my child. Who's familiar with the proposal from the AASA? Tell me your name. What's your name?
Carrie.
Carrie. Oh, Carrie, can you tell us what that is?
It's been a bit since I read it, because I think that was 2013.
Yeah.
But I know that they recommended that facilitated IEP become mandated. That due process was reserved for, I think, cases where everything else failed, and there was, I think, an intermediary step where an expert, or maybe that was part of the due process step, again, it's been a bit, where an expert looked at the IEP. I thought that was really interesting, and somebody from on high, maybe in academia, that could look at at the IEP, think about evidence-based intervention, do some observation of the child,
Mhm.
and write an IEP. I think that the parties were then obligated to see implemented for a period of like 30 days.
Right. So this is actually what it looks like. The proposal was to mandate a facilitated IEP. Okay. So I'm looking at this and I'm thinking, well, what do you do if the district said your child's not eligible? Right? What are you going to do right here? You don't have an IEP, right? Because the district said your child's not eligible. But this was supposed to be a mandated piece. You couldn't file due process unless you went through any of these, according to this proposal. And then after that, you had mandated mediation. And then after mandated mediation, you had a mandated proposal. It was taking that SpedX program out of Massachusetts, which was a voluntary program, now not being used any longer, but making it a mandated program where the parties would have to submit the dispute to an IEP consultant who would write an IEP for the child that the parties would have to agree would be implemented for some period of time. And only after all of that could you file due process as a parent. And the proposal was pretty explicit in saying that it wished to create a lawyer-free system, which I take personal umbrage to. No, I'm just kidding. Right. Okay. And really said this is going to abolish due process as it exists, and it's going to create an entirely different structure, right? Create an entirely different structure. Okay. So that was the proposal from the AASA, and it got a lot of pushback. Okay. The American Association of School Administrators. American Association. What?
Oh, I guess I thought it was the
American Association of School Administrators. Okay, thanks. Of school administrators. Okay, so then some other scholars said, look, the system is pretty okay as it is. We just need to do some minor tweaks, okay? Congress the next time around should amend IDEA to make explicit that expert witness fees can be recovered in a due process proceeding. That there should be some relaxation of the rules about exhaustion of administrative proceedings, okay? So whether or not you need to exhaust so that you could actually put things together and have a more cohesive, if you have a dispute and it's taking a while to get resolved, you gotta file due process over and over again. Eliminating the two-tier structure. Enhancing the training of independent hearing officers. And one of the other things is clarifying the means to enforce a settlement reached in a special education dispute. Okay, there's some vagueness about how you go about enforcing a settlement that's been reached in a special education dispute other than a mediation. So if you reach a settlement in the resolution session, how are you going to go about making sure that the settlement agreement is enforced, and if you feel that it's been breached, what do you have to do then? Do you have to file due process, or is that a settlement agreement that was reached that could be actually enforced directly in federal court or state court? Okay, so those were sort of the minor tweak ideas, okay? Minor tweaks, adding IEP facilitation. I know you all are you're an audience that's very familiar with IEP facilitation, right? The radical overhaul, public enforcement, and the voluntary binding arbitration proposals.
Who would determine the standards for witnesses that were expert?
Well, I think that would probably follow the federal rules of evidence, right? So the federal rules of evidence determine when an expert is qualified to render an opinion. Yeah.
Superintendent's Association.
American Association of Superintendents. Thank you. Okay, so what I decided to do after I looked at all of these different proposals was I decided to do a survey of special education practitioners. And I had 393 individuals complete the survey. I went out and looked as far and wide as I could to capture as many people as I could, okay? The Education Law Association, COPA distributed the survey for me, COSA distributed the survey for me, some special education organizations, some folks on listservs distributed it for me, although I didn't distribute it in Puerto Rico. okay, which has become an active jurisdiction for special education disputes.
Is there anywhere that it isn't?
That an active jurisdiction? Yeah, there are some jurisdictions that aren't very
It's
active.
very active in Puerto Rico.
Very active in Puerto Rico, but we have some jurisdictions where there isn't a lot of activity in terms of special education
There are
disputes.
states that you can count the due process request on one hand.
Yeah, yeah. So I had 156 respondents say that they represented school districts, and 243 respondents said that they represented parents or children or families. Okay. And what I did is I was interested in certain pieces. The survey actually encompassed some other things, but it got to be a little bit too bulky. So I was asking about training of hearing officers and such like that. But what I wanted to do, what I really ended up focusing on were the pieces of the survey that talked about things that were not in the current federal scheme, so IEP facilitation and voluntary binding arbitration. I should clarify about IEP facilitation. You know, when I'm talking about IEP facilitation, I'm not talking about a different process, but I know that some of you are in a state where at the statewide level there's no IEP facilitation. In other words, your state educational agency has not put any sort of plan or process in place, but you will have it at the local level, right? So we have about 29 states that have it as a statewide program that should be in place. And then in other states, it's here or there, right? And then in a few states, I think it's just really not available at all. And so, for example, I know that New York has considered it, and yet it hasn't happened at the statewide level. New York being one of our most active jurisdictions that, you know, probably could benefit from an IEP facilitation program. But I was looking at IEP facilitation as something that would be added into the federal statute, where Congress would say to the states, as a condition of receiving your federal funds, you need to have a plan or program in place to offer IEP facilitation on a statewide basis, okay? Voluntary binding arbitration, which is not in the current federal statute, right? But is that something that should be added? And then things in the current structure. I was actually really interested in the resolution session, and I was really interested in the one-tier versus two-tier structure. One of the reasons I was interested in the resolution session is because when I went back and looked at the legislative history for the 2004 amendments, as a means of resolving special education disputes, that was the least discussed means, and it was the one that ended up in the statute. Okay? So there were references to IEP facilitation, there was references to arbitration, there were references to making mediation mandatory, and then boom, when the legislation was passed, we have something called a resolution session, right? I don't know if any of you have any of our DCers have any thoughts about how that.
OSEP does not have an official position on that.
Okay.
So I'm the first one out.
You know.
And I know that to some extent that came out of the experience, I believe, in Maine, where a parent was allowed to, the state could not be represented, the district could not be represented if a parent wasn't represented, and that contributed a little bit to this notion of creating a forum where attorneys would be kept out unless both parties were going to be represented.
Mm-hmm.
My sense was that also developmentally that this was sort of something that people landed on as perhaps a more comfortable alternative to binding arbitration, which folks were very concerned about.
Right. So me not being inside the Beltway out in Akron, Ohio, right?
I'm way out.
And looking at it years later, you know, you sort of sit back and scratch your head and say, how did that, it felt like a compromise. It felt like a sort of a last minute kind of, let's try this, right? You had your hand up.
Well, I picking up on what Marshall was talking about, I'm still unclear why there is such blowback on the notion of the voluntary binding arbitration model, for no other reason than, at least in my experience, and I'm from Illinois, something has to be done to take the control of the process out of the parties' hands, or at least to some degree, because that's resulting in 8, 9, 10-month hearings. And I'm talking typically in situations where both sides have counsel.
Mm-hmm.
they jockey for position. I mean, they get into ridiculous notions of throwing discovery motions at each other and stuff. And at least if you look at it historically, from when IDEA was first born back in the mid-'70s, that is
I agree.
nothing like what they
Contemplated, right. Yeah,
It's turned into a litigation monster.
Right.
At least in where I work.
right.
And so I don't understand what the resistance is or where the sources of resistance are to the notion of having somebody that stands as a neutral that can kind of control the process of gathering the information and then reaching a determination that hopefully is fair to everybody.
Right. And I think philosophically, it's a great idea. The devil would be in the details.
Right.
But one of the questions I think really is whether it's politically feasible. I don't think it's politically feasible to replace the due process complaint process, that more adversarial process, with binding arbitration. I wonder about I'm talking purely the political feasibility. In 2004, they were talking about adding this as another avenue that families could go down.
Well, whether it's called binding arbitration, I apologize, I don't mean.
Binding
to
just means
belabor
you
this.
can't appeal it.
But
That's it.
there's- But as I think you pointed out, there's nothing in IDEA that mandates an adversarial hearing. Nothing.
Well, I guess I have to disagree with you a little bit because,
so?
well, the procedural safeguards have lots of rights for parents, which would mean the right to control that
I
due
agree,
process
but no-
proceeding.
But if you take all of that and you add it up, it still does not require an adversarial proceeding like what we deal with on a pretty regular basis in the relevant due process. Where you're mandated to have direct and cross-examination of witnesses and things like that. I mean, I think the only real rule that's there is on the exchange of documentary evidence and witness lists and so forth.
Well, that I agree with you.
Yeah.
I mean, the making due process into looking like a litigation has
Like a trial.
evolved over the years as hearing officers borrow from what they know from federal and state litigation, right? That's definitely true, right? So rules, you're right, there's nothing in IDEA that talks about rules for
And I
direct
think-
or
I think we've all grown
cross-examination.
into the assumption
or-
that a hearing has to look that way, and I don't see anything in IDEA that requires that.
Right, I think the practical problem is if that's the system that we have, the
Sure,
hearing
sure.
officer is concerned about creating a proper record and the parties have to create a proper record, right? So that's where we end up. If it could be substituted for some very specific proposal that would have its own rules for presentation of evidence, direct and cross-examination, number of witnesses that could be called, that would be great. But do you think we really can get Congress to do that? Yeah.
So I think what Andy is bringing up actually does open an interesting conversation around what each of the due process hearings looks like, state to state. And a lot of that could have to do with the forum in which the hearing is being held. So there are some states where due process hearings are still conducted across a table.
Yeah.
With a pro se parent and potentially even a pro se district. More likely to have a pro se parent. But that it's at a table and it looks more conversational in style than states that have their due process hearings potentially being held through an
Right.
Office of Administrative Hearings, which is a court in that state.
Right.
Here's different sorts of. So that's another
Right.
sort of a piece to be thinking about when we think
Right.
about what it's looking like. The forum is important.
I mean, that's a, boy, I'm just like getting jump started with ideas because really, you're right. The federal statute requires the states to have a plan in place. And really, there's nothing that would necessarily prohibit the state of Illinois from saying, here are the rules of procedure for a due process hearing. And they could be different than the rules of procedure for a piece of litigation that's in Illinois state court or the rules of procedure that are different that are in federal court. I mean, there isn't anything that the State Department of Education could promulgate regulations that says here are the procedures for due process hearings. This is our plan. right? They could do that. The voluntary binding arbitration, I have to say, if it's an alternative to due process, I personally have an issue with it because I think it would actually exacerbate the wealth disparity problem, because here you have no right of appeal and here the panel is supposed to be more active. So it would be an attractive option for parents who have less means, right? They could rely on the panel to seek out some evidence and ask for witnesses and do some of that examination, right? But they have no right of appeal, right? Whereas wealthier parents who can afford to hire an attorney would probably shun this option because they would want to be in control of the litigation. So if it's an alternative to our current due process structure, I think that could be problematic. Yeah.
For the voluntary binding arbitration, the idea that is the panel like a panel of people who know special ed, so this is not like just allowing parties to just be agreeing away their rights or agreeing to things that are not even required under IDEA, or I'm just kind of trying to get my head around how that would even work.
Right. Professor Rosenfeld's proposal, he says, is broad brush, but in broad brush he's proposing a panel of three, minimum, a panel of three. Someone with expertise in the child's disability, a lawyer, and an educator. So, yes.
That's sort of a more general question, which is, in the scheme of things, are there other areas of IDEA that could be addressed that would actually help reduce disputes, period? I mean, are there things that could or should have been clarified in 2004 that weren't, that could be helping reduce the need?
I don't. Yeah.
So just on that thought, the notion of the option of having a facilitator at an IEP team meeting.
The option of what?
Having a facilitator at the meeting. So if that were addressed potentially in an earlier part of the law, not in the procedural safeguards or dispute resolution sections, but maybe earlier as an option for IEP teams,
Right.
Thinking about it in a more,
Yeah. Yeah, and that was part of some of the things that were floated. But yes, the notion that you should move move upstream, so pre-filing of a due process complaint, whenever that relationship starts to break down, have some procedures in place to help keep it going. I mean, there are things you can do, but like politically or fiscally, I mean, it would be great for parents who you could have some kind of a means test, and if you're a family, or if your income and your education level, you should be able to have an advocate. But who's going to pay for it, right? I mean, who's going to pay for it? That kind of a thing. Yeah.
I do dispute resolution between families and schools, and I think one of the big challenges I see is how to achieve a satisfactory level of independence and objectivity that is perceived as such by the families when you have a system that is sort of funding its own solutions and sourcing its own solutions, and that tends to create a perception on the side of families, for example, that this is just more people in the employ one way or the other. They used to be employed, they are employed now. They only come from that whole perspective, and so I feel like, how can we find a process that throughout really does feel like a more balanced, multi-partial kind of process? I mean, I think what I see breaking down is we go through all of these steps, starting with even the earliest step of parents and educators sitting around a table, and those conversations are not actually succeeding. And I think that continues all the way through to the point where parents come away from a due process feeling somehow that it was rigged or stacked against them. Still, they were supposed to get this audience with a kind of an independent judge, and it still didn't feel, they felt brushed past. They felt like, they were at a disadvantage, that what they wanted to get out wasn't really, I hear from parents so many times, I wasn't really allowed to ask my questions. I had things I wanted to share with the judge just pushed those aside. So I think, a more kind of fundamental rethinking of what does it really mean to kind of include everybody on all sides of this dispute, so that the process feels like it has integrity.
Yeah. Any thoughts about we could move stuff upstream, like other?
I guess a couple of thoughts. I really, well, first a big thought, which is that I'm nervous about the idea of messing with IDEA at all. That I really, as I look at our current Congress and national leadership, and I imagine that this law gets cracked open, and whether at the point that it gets put back together, we're likely to be happier or less happy than we are now. I'm not typically a gloomy Gus, but as I kind of look at.
So you like gridlock?
Well, I wouldn't. I guess I just would raise as a concern that it's not a certainty that if we begin to mess around in this area, things are going to get better. The other concern I would have would be, I think that when mediation was added, that mediation is a very valuable process, and that to some extent when it became part of the law, it really stifled some of the very exciting ways that it was being conducted. Somebody mentioned solution panels, which don't satisfy. In fact, they were a mediation process that was being used to resolve special ed disagreements, but at the point that the law came in, it was very explicitly a single mediator.
Right.
It was also included an assumption that people would be knowledgeable about special education law, but no way to really characterize whether you're knowledgeable or not. And I'm sure it's a very, very complex law, and I'm not sure how many mediators are knowledgeable. And so as I hear people talking about adding IEP facilitation and think about the richness of experience and the variability in terms of the ways that different states and that some of that, if we go in and regulate around IEP facilitation, we may really lose the ability to do some of our very best work because of the restrictions that would be put in by adding it to the law, unless it's added in a vague kind of a way. And
Well-
it's already happening without being added in a vague way.
It is happening without being added in a vague way. I mean, there are places where IDEA is pretty darn vague, right? I mean, who knows what an appropriate education is anyway, right? I understand what you're saying, and that's certainly a point to consider, whether or not if Congress messes with IDEA, it will mess with it the right way or the wrong way, right? It's definitely a point to consider. However, do we have somebody here from Oregon? Right. Didn't Oregon just stop doing IEP facilitation?
Am I the only person here from Oregon? Amy, you're back there, right?
Yeah, I am. I think they're in an evaluative process.
Okay.
They had started, I think, more on a pilot level. It wasn't an official rollout. I think it was being offered. And again, I'm with Cadre. We don't work for the department.
Right.
So we're not insiders. Don't have.
Right.
As a state, we're also experiencing outrageous fiscal compression. So we are now 46th in the nation in terms of average per pupil spending, and I think we are financially in outrageous disarray, and so to some extent, an awful lot of things that we've taken for granted for a long time simply are no longer there.
Right. So the downside is if it's not in the federal statute, then there is the flexibility that you like and discuss. The downside is if it's not in the federal statute, the state can discontinue it, right?
Sure.
Yeah.
I see also states defining who can be a facilitator at IEPs. And a lot of times that training goes to individuals who are not in parent organizations or parents, but more educational settings or educational providers. And I don't know, I mean, I've worked with a lot of educators, and I really believe we're all team members and we work well together, and I've always felt that way. But I have had families say to me, that doesn't seem very neutral. It doesn't seem very equitable. And, I can't.
In terms of training, or actually how the facilitator
Well, how
behaved
is
in the
the
meeting?
Facilitator being engaged.
All right, well, so that's great, because that's a great segue to what the survey said about IEP facilitation, and then this is where you guys get to tell me, what you think. I know this is kind of a jam-packed slide, but So I asked whether IEP facilitation was a valuable vehicle to resolve disputes quickly. And the bottom line is that most of the answers, whether the survey respondent was self-identified as a school district attorney or self-identified as an attorney for parents or children, was somewhere in the middle, okay? So 52 sort of agreed of the school district attorneys, but there was a substantial that neither agreed nor disagreed, and then disagreed and strongly agreed. And in terms of avoiding due process, which was, you know, don't we all agree that's like that is the main goal of IEP facilitation, is to avoid due process? They were also sort of, right? So only 7% of school district attorneys strongly agreed and 38 agreed, but there was a substantial that took no opinion or either disagreed. And then in the parent-child attorneys, it was even more starker. Only 4% of them strongly agreed, 23% agreed, but 43% of the parent-child attorneys disagreed with that proposition. Yeah.
Do you have any sense as to why they would be responding that way?
Yes, I do. So I also asked them, I asked for narrative comments, okay? So these were some of the comments, and of course I've compiled and compressed them a little bit, but what I got was, in theory, IEP facilitation is a great idea, okay? It's an excellent way to keep the process on track. It's particularly useful when there have been multiple IEP team meetings and personalities have stood in the way in terms of meaningful discussion. However, there were a lot of negative comments about training of facilitators. Maria.
I just have a question about how this works. New Jersey's starting to look at this, and part of our problem is just the sheer volume of classified students we have. So we're trying to figure out how to do it, who would be the facilitator. But it seems to me the issue you have is bringing in a third party who doesn't know anything about the child, which is kind of what a mediator, complaint investigator is anyway. But with this, that's what we hear from parents. Like, why are you going to add another person in the process? It just seems to me to slow it up even further. But we haven't done it, so I'm just kind of curious how it actually works. Like, which I guess maybe goes to the training in other states. Who are these people?
Yeah.
I'm the mediation facilitation coordinator in Ohio, and all of our mediators are professional mediators. They are then trained in special ed law to be facilitators as well. And so they are professional mediators, and then they also have specific knowledge about meetings.
Mm-hmm. Yeah. Wait, I want you to get on your phone, go to Kahoot IT, because Maria, I have some of these comments here, and the very comments that were just on the slide, and I want you to tell me if you agree or disagree, and then we're going to talk about it. What does the audience think? Could we do better with IEP facilitation training, or do you disagree with the comments from those? Now, granted, these are all attorneys. These are practicing attorneys, okay, that are in my group. By the way, when you log in and you use this game pin, it's going to ask you for your name. So you can put in your initials, or you can put in a pseudonym. Yes?
So is all the feedback from attorneys?
It's all from attorneys.
So the majority of our IEP facilitated meetings do not involve attorneys.
Yeah.
They are just coming from a request from the district or a request from the parent. I mean, if we looked at our data, you would see that it doesn't involve. And we have pretty successful meetings, and our goal is not about preventing due process. Our goal is getting through the process, whatever the IEP process, developing a solid plan that will best meet the child's needs. That it is a process in our
And that's right.
It's not going in with the mentality of let's do this so we don't go to due process. It's more let's go in so we can get through whatever we need to get through.
Right.
Wherever we're stalled.
And that's a fair criticism, and I should say that the survey didn't say an facilitated IEP meeting that you as an attorney were present at. They could have had a client who previously went through IEP facilitation and it didn't work for their client, okay? Yeah.
It's likely to adversely affect fee collection, that if you offer a
Right.
process that doesn't include attorneys.
Yeah.
And I was just also curious, were these attorneys from states that did not currently have, or at least some of them in the states that did not currently have IEP facilitation?
These were attorneys who said they had a client had experience with IEP facilitation. Okay, yeah.
Are these all Ohio attorneys?
No, this is nationwide.
Because not this past year, but the year before, 90% of our facilitatees resolved favorably, either an evaluation team report or an.
Mm-hmm. Right. Ohio is one of the states that offers IEP facilitation as a statewide program. So the Ohio Department of Education, right? Yeah. Mm-hmm. So kudos to Ohio for doing a good job with IEP facilitation in terms of actually how many people still have to get on? Still have to get on, or how many people who wanted to be on?
But we don't know where to go as far as saying my
It's just Kahoot.it. There's no .com or anything like that. Hmm?
You have to sign in.
You just have to use this game pin right here, 6120, and then enter, and then put in like initials or something. No? Well, you don't create it.
I Google searched it.
Oh, I'm sorry.
Directions.
You know,
Yeah.
while everybody's coming on, I just wanted to go back to that reform issue before, like the binding arbitration question. It seems that there's enough evidence right now to show that localized, locally developed ADR processes are so effective that if there's any resources that should be put in, it should be put into that prior to the more formalized systems. In California, there are thousands of due processes requests each year, and they resolve 90% of those prior to any hearing, actual hearing, using an ADR process such as mediation or another type of a process. So it leaves very limited case hearings, and at that point where a parent has to go to that far and still is able to access and make use of an ADR process, would just suggest that we should put in maybe the energy even more at the local level. Don't regulate it, leave it to local communities to develop their own opportunities that work, and maintain that due process and state compliance with the existing IDEA so that there's always an opportunity for a decision maker that's final when it's needed. But it just suggests that it's in everybody's interest. School districts will want to do this, so there's no need to motivate them in any other way than their own self-interest that they should participate in this.
Right. Well, I agree, except the problem with that is what do you do with the locality that doesn't develop that stuff?
Well, then the option remains to continue and to go up through more formal areas. If it's not in their interest to do it, they won't be self-motivated, and statute and regulation is going to force them into it. And the binding arbitration one, if two parties can't develop it, what would be the likelihood of implementing someone that's forced by a third party? So to me, that's somewhat problematic, that they would be willing partners when they really had no say in that decision that was binding.
That's a
So
fair. That's a fair
there's-
comment.
There's some thoughts about.
All right,
whether-
on your phone, what do you think? IEP facilitation is an excellent way to keep the IEP process on track in terms of coverage of topics, management of time, and management of conflicting personalities. What do you think? You agree or disagree? I'm sorry, it ended up being a little too small. IEP facilitation is an excellent way to keep the IEP process on track in terms of coverage of topics, management of time, and management of conflicting personalities.
Is this the same questions on this piece?
Yes.
Okay.
Mm-hmm.
Can we just fill this out?
Mm-hmm. So everybody agrees, right? Yeah. And that's what my survey showed, even of attorneys, right? Even the attorneys agree that this is a process that is a valuable process, right? It's a valuable process. What about this one? It's also on the sheet of paper in front of you. I'm sorry, it's a little bit small. It's particularly useful for those cases where there have been multiple IEP team meetings and personalities have stood in the way in terms of meaningful discussion. I think everybody's answered. was whether it's a good idea when personalities have stood in the way. So we had 3 that actually disagreed. I don't know if it was the way. These are the comments that I received from survey respondents. Anybody, one of the 3 who disagreed, want to voice an opinion as to why?
Well, mine is one of those votes that wasn't really meant to be. I meant to
Oh.
scroll something down and it took the button.
Okay.
But at the same time, I have heard people kind of make comments, we've been through this and we've been through this, and like bringing in somebody else just kind of, didn't really help the process. So if I thought about it, I might have still voted yes.
You might have still said no, right? So maybe there is this notion that repeated IEP meetings actually have a diminishing return to them, don't they? Right? If you've attended 2 IEP meetings and it's really gotten kind of acrimonious, that the 3rd meeting, even if it's facilitated, may have less of a chance than if you had caught it a little bit earlier. That's not to say we shouldn't do IEP facilitation, but just to think about the way the process is structured and when is it available and what kind of dispute or issues is it particularly suited for. Yes?
I just wonder if it has anything to do with the skill of the facilitator. The more entrenched the problem, the more skill you need with one of the issues around training, and that's where it's going to show up. So it's not the easy one, but more difficult.
Wait, just you had your hand.
I was just simply going to offer the other idea that it could be that the parties have met a number of times thinking, well, we can do this, we can get this worked out, but in fact keep hitting their heads and therefore maybe are more receptive to the idea that somebody else can come in and help us.
Well, that might be true as well. What were you going to say?
I used to facilitate IEPs in North Carolina, and I know something that I did a lot of was spend time on the phone with the parties ahead of the meeting and kind of pre-resolve, like, what do you have to have, why, and getting to the bottom and kind of getting those issues out to me so that I could process it, kind of pre-mediate. And I think that, and that's probably, the person that was in charge of our facilitation program really, at that time, and it's 2005, 2006, really emphasized that piece, that pre-meeting piece, and it made all the difference.
Right. I wonder about I think that's a great comment, because I wonder about what the parties' expectations are about what the facilitator is going to do, because I've attended a couple of sessions and there are widely varying models about how to be an IEP facilitator, right? And if you are more of in the mediation mode, like I really want to know what the issues are before we come, and I'm going to set an agenda and say I've talked to both of you and I understand that these are the issues we need to look at and let's dig down, or a little bit more hands-off approach, that the parties understand, and whether or not, is there a best practices? Is there really one model that's better than another model? Because, and this is your opportunity, I had a lot of comments that the facilitators were not trained, and specifically that facilitators in a lot of cases, now this is nationwide survey, right, really actually didn't even understand some basics about special education law. So that the facilitator was in the IEP meeting saying, can somebody tell me what LRE is? Okay, and you have to wonder if that's valid. You have to wonder whether or not that is not actually contributing to frustration in the meeting, and whether it's local or on a statewide level, should there be some development of best practices for IEP facilitation, and the extent to which it should include good knowledge of special education law? Because I've seen some things that actually say, as a facilitator, it's kind of okay if you don't really know about special education law, because if you're confused, everyone else in the room might be confused. And that, frankly, doesn't make any sense to me, right? But you tell me what you think, okay? What do you think? Again, this is also on your paper. I apologize, it's so small. It says, I do not believe that IEP facilitation is being conducted by highly qualified individuals. They have not been effective in resolving contentious matters. Their function appeared to be nothing more than conducting the meeting. Do you agree, disagree, or some would agree, but the statement overstates the problem? Basically, that the facilitators are not highly qualified and that they're really just conducting the meeting. Like, You go first, you go second. And is that what we want? Well, we didn't get very, okay, right? So some would agree, but it overstates the problem. Like, is this a problem for current IEP facilitation?
For any practitioners, like due process hearing officers.
So it's just a problem within the system, period,
Yeah,
training.
for doctors or teachers, I mean, there's a normal distribution. Some people are very good, some people are okay, and some people are not particularly good.
Right. Is it a problem? Is it more of a problem because IEP facilitation is voluntary on a statewide, if the state can do it, if the state can fund it, if they don't have the ability to fund it? I mean, would it be a better dispute resolution mechanism for special education nationwide if we had something that was more formalized, I guess is, I'm raising the question.
Well, I mean, I think some of the problem in the IEP facilitation realm parallels what I directly know within the due process realm. I mean, I'm a due process coordinator. I have to hire hearing officers, and I'll tell you, you know, finding people with the level of expertise I would like are nearly impossible to find, because, you know, I mean, here's the thing. I've been doing this for 25 years. I still have to go back to the law and the rules and stuff and say, do I remember this procedure? These are very, very intricate things. And to take a hearing officer who all too often won't have this background, because I'm sorry, finding a trained attorney that really knows special ed law is not real easy. I don't think in a lot of jurisdictions. It's a pretty small pond.
Mm-hmm.
And, you know, and you've got, if you're lucky, a week of intensive upfront training to do. Well, to expect them to have the expertise of somebody that's been doing it for 25 years in the space of a week that's a fool's mission. And yes, I mean, I think the training up front needs to be very intense, but I think we also have to be realistic that there's going to be a lot of people that are going to need time to learn the ropes. And if we want these programs up and running, then we're going to have to either figure out how much of an apprenticeship period those individuals might need, or we're going to have to kind of iron out the kinks as we go along.
Mm-hmm.
So.
Yeah, yes.
Well, here's an extremely naive comment, because I don't know what I'm talking about. But it also seems to me it depends on what is the perceived or articulated role of the facilitator. One possibility is to reach agreement between the parent and the school with a solution that both will accept. Or another is to develop a program in the best interest of the child. Those are not necessarily the same thing.
Mm-hmm. Right. I guess what I'm trying to do here today is to raise sort of the consciousness level that there's this widely varying approach to IEP facilitation and training, and that it can stand in the way. And that's as a lawyer, I would, you know, I'd never represented a school district, but I would be like, no, it's what parties can agree to, right? Right? If the parents are willing to agree to it. That your question to me sort of rang more like a Rowley problem. Like, are we maximizing potential versus providing an appropriate education? But if IEP facilitation is I support it, if it is a good upstream pre-due process way to resolve disputes, do we have some issues that are standing in the way in terms of primarily training is one of the things that I saw, that this notion that you can be borrowed from other disciplines. You could be a mediator that's been primarily mediating construction disputes, right? But because you have your mediator certificate, you could do IEP facilitation because you have some knowledge about mediation, communication techniques, and whether or not there should be some more look at what should there be a stand. I know you're all about local, right? But should there be some kind of a standard model?
Local, that's quality.
Right, or a best practices.
And if any trade group comes together and gets standards and qualifications, that's an appropriate level of training. Absolutely. I wouldn't disagree with the quality issue at all.
Yeah, okay, yeah.
I fully support that.
In Ohio, we definitely cut back, excuse me, I have a bad cold, our roster. We only have 9 people on our roster.
Right.
They they do other mediations, but they have been highly trained to do special ed.
And that's great.
Mediation and facilitation.
See, and that's great. That's great. Yes, sir. Oh,
Yeah, I think one question also to take into consideration is who's paying for the mediation or for the facilitation.
right.
That is an issue that would always be
Funds.
from the parents' perspective.
Right. I agree, yeah.
So, I work in the upstream, so I definitely support, making that part work better as a preventive measure, but I also feel like I often see the education realm lagging behind, other major arenas where either constitutional fundamental rights are at stake in terms of, the kind of protections it offers people, and I don't, as time goes on, I understand less and less why that's the case, take like language access, for example. You go to the medical arena or the courts and you see all kinds of really good services for people to get language access. Then you switch to the educational arena and it just all falls apart.
Yeah, we talked about this
Yeah,
over lunch, right.
And suddenly it's all very permissive, it's very vague, and
Right.
I get the kind of incredible costs associated, but Washington State, where I'm from, education's a constitutional right. So you're talking about when these processes don't work, people being really sort of
Denied.
barred access from that,
Mhm.
and yet I think we have a lot of work to do, and just we can tweak and add and all kinds of things, but what about just looking at the core function? Are people accessing their due process rights the way they would if as they do in other arenas? Do we have enough pro se options? Do we have enough people being assigned attorneys where they need them if they can't afford them, so they're not just going in there on their own with So I mean, I kind of wonder, why aren't we duty bound to look at those pieces of the process at a minimum?
And I agree with you. I think we are duty bound to look at those, I just want to finish up, and I appreciate that. I just want to finish up on IEP and actually thinking about what you said, Marshall. It's like, I look at this on a nationwide basis, and I look at we have no New Yorkers, nobody from New York, right? So I look at a jurisdiction like New York, which is one of our most active jurisdictions, a 2-tier jurisdiction, so the administrative process is very long, and also a state that doesn't have, on a statewide basis, any IEP facilitation.
They're on their way.
They did
got a
have-
training contract. They've recruited facilitators.
Yes.
They're piloting on the brink of piloting in 2 of their most contentious districts with a view for
Right.
going statewide. But
Right.
They're being really thoughtful about
And I
quality
did, right, I did see that out of the New York State Education Department, that they are talking about and beginning a pilot project. So, but it's like, if you think about it as an upstream pre-due process for some of those active jurisdictions, I don't know. I sort of look at it and think, if it's a requirement of your receipt of federal funds, but you can develop the program as you wish, right? So I'm talking about something vague that would say you should have this kind of a program in place, because then you would have it everywhere, right? So I want to switch to the resolution session. I really appreciate all your comments. We're jumping around a little bit, but I want to hear what you think about the resolution session, and also to share with you a little bit of data about it. Because the survey respondents, again, these were attorneys, really said that they did not believe that the resolution session was a valuable vehicle to resolve special education disputes. And they said that their clients had not had substantial success in resolving special education disputes. When they were asked if it most often resolves the dispute, they were a little bit on the fence about that. But if you look at some of the comments from both sides, so both school district attorneys and parent-child attorneys said it's unproductive and it's a waste of time, and in most cases we waive it and would rather proceed to mediation. The school district attorney here, I was a comment that said voluntary mediation tends to be far more effective if used, and that both parties seem to take comfort in and benefit from the facilitation of a neutral third party. And this was one thing I was looking at, because I was like, what, this was just sort of thrown in there at the end as this additional meeting that's going to take place after due process, and is this really working? I just wanted to point this out too, that both sides of the table in terms of attorneys said This is a place where there's really no collaboration going on. This is a discovery tool, right? So the school district's attorney is going to try and take discovery, or the parent's attorney is also trying to take discovery. Because the resolution session, unlike mediation, it's not confidential, and things that are said in the resolution session can be used in a subsequent due process hearing. So you really, I have this very substantial question in my mind as to whether or not this is actually doing the job that it was intended to do. And I want to get your opinion about it, but I wanted to show a little bit of the data as well. So data that was published by OSEP for 2011 and 2012 had most active jurisdictions by number of due process complaints that were filed. And they were California, the District of Columbia, Illinois, Massachusetts, New Jersey, New York, Pennsylvania, Puerto Rico, and Texas. 2 of the jurisdictions had settlement rates out of the resolution session of 25 and 20%. 3 jurisdictions had settlement rates of below 15%, and the remaining 4 had settlement rates of below 10%, with California being at 1.8% of cases being resolved at the resolution session, and Massachusetts 3.8, New Jersey only 2.1, New York 7.8. Yeah. That's right.
Extremely, extremely low number.
And that's a
resolution sessions, and it was probably the legal aid folks, the public interest attorneys who were doing the settlement. So I just,
And that's a really good point, because this is only of the ones where resolution sessions were held and not waived. So actually, I looked at 2. If you look at New Jersey and New York, in New Jersey, 85% of the cases where a resolution session was held, it settled, but they only agreed to have a resolution session in 2.5% of the disputes, right? So if this is something that's in the federal statute, but in New Jersey it's being waived 97.5% of the time, then it's really not an effective dispute resolution procedure just because the parties aren't doing it. Maria?
Well, and just explaining why that number exists is we hear over and over again that it's a waste of time. If parents have to go through due process, why are we going to try to get them resolved at the end? Just go to mediation, get to the neutral party, or that's how we're talking about facilitation.
Right, yeah.
So in California, different areas do it in different ways. So in our county, we have an independent child advocate who can come in. It's more like a confidential resolution session / ombuds session / mediation. People use that a lot and are very successful. We don't even talk about a resolution session.
Well, that's my point. My point is this thing that Congress put in 2004, are the parties using it, and is it working? If the parties aren't using it, then it's just an extra, I know I'm stumbling, it's just an extra thing in the statute that's not really doing its job, right? If the parties are using it, but it's not resolving disputes, then it's also not doing its job. So in New York, the resolution session was held in about 90% of the due process disputes, but it only resulted in a settlement 7.8% of the time. So the parties participated, but they rarely came to a resolution. Now these are just illustrative, and I appreciate your comments about the District of Columbia, but if you take a look at some of the data, you really have to ask yourself the question, right? If you're having it a lot, but you're not settling cases, or if you're waiving it a lot, okay, granted, it's successful in the very small number of cases where you have a resolution session. There's nothing, if it weren't in the statute, there's nothing that prevents the school district from inviting the parents to come to a meeting even after due process has been filed, right? But to mandate that there is this resolution session, that it's going to have a timeline, okay, we've talked about the fact that the 45-day timeline itself is unrealistic, but the resolution session extends the timeline, right? So it's just, I'm just asking, raising the question, I want to know what your thoughts are about whether or not this is proven to be a worthwhile dispute resolution mechanism. So anybody, tell me what your thoughts are. Yeah.
It's a mess. I mean, at least in the world I work in, it's a mess. It rarely results in any kind of satisfactory feelings. I mean, there are certain instances, and I'm one of the cited states, Illinois. It does occasionally result in a withdrawal of a due process request. But I've also had kind of anecdotal reports back and interacting with parents saying, yeah, I agreed to this, but I kind of felt bullied. I walked into a room with 8 other people, and they shoved a piece of paper across and said, sign here, and I wasn't sure if I should or not, and I ultimately did because I'm very skeptical about how effective it is when it occurs, but in the vast majority of the cases, they're bypassing it because, I already hate these people. I just filed for due process. Why are you making me sit in a room with them?
Right, yes,
It seems like it's almost built on the assumption that people haven't talked.
yes.
And so the idea, it's like, if you're one of the few people who developed a complaint without having actually contacted the school, like the school principal saying this is the first I'm hearing about it,
Mhm.
okay, a sit-down session makes sense, but it doesn't seem like that's really, it's a false assumption. I think that it happens occasionally,
Right,
but, and those are the occasions, right, the 7.8 and the 2.5.
right. Where it's out of the blue, a due process complaint. And that, you could see that that would happen, right? But as I said, even though, if it's not in the statute, there's nothing that requires a school district from calling up and saying, we didn't realize when you left the IEP meeting 5 days ago and said you wanted to think about it, that you were, right? Can we come in, will you come in and sit down and we can talk about it, right? I saw, yes.
In our state, primarily all of the due process hearing requests come via parent attorneys. And the frustration that I hear with a lot of other people expressed with ineffectiveness of the resolution, I initially witnessed that, but just over the course of the last 2 years, we do have one school board attorney group that seems to be able to sit down at the table with the other parties at the resolution meeting and quite miraculously, because I thought it was like, an impossible situation. Why am I telling these folks to make sure they always have these meetings whenever they never ever were?
Mm-hmm.
But then all of a sudden, this one, school board attorney group came in and was actually being quite, and continues to be actually quite successful in getting the resolution meeting to work and coming to a rapid agreement. So I think in some ways, what we might be having here is just self-fulfilling prophecy. They file due process, they want to fight, they don't want to sit down, so this is just a wasted thing instead of looking at it as having the potential to be successful.
Mm-hmm.
Or that could just be an anomaly.
Well, but I think that's great. But there is, you do have to think about it. I mean, what you said, just the notion that the parents have gotten to a point, primarily, we know it's primarily parents that file due process, right? That they've gotten to a point where they file due process. Have they had sort of this switch in their mind? I've stopped talking now, and I'm fighting, right? And is this ill-placed? It may be working, but is it ill-placed because it comes too late in the process where the parents, by virtue of filing that piece of paper, have made that sort of psychological shift? Somebody else had their hand. Yeah.
Maybe we have an anomaly going on where I am in Southern California, but we had 57 due process filings in our 10 districts last year that I oversee. And we've done a great job, I think, of training districts on alternative dispute resolution. We're even into the districts training assistant principals and principals on the process. We train people that actually come from all over the state on facilitated IEP. And then I have a due process manager position that they do all things full continuum. We were able to resolve all 57 without going to hearing on any of them last year. And I think it's a combination of the resolution sessions and the mediation that eventually prevent us from going to full hearing.
Mm-hmm.
Although I will say that we, I think, have a reputation where attorneys, I would venture to guess, I can't prove it, say something like this: let's just file for due process to threaten them. Then we'll go into the resolution session, or if necessary, mediation, because they're gonna cave and they're gonna give us something. So we're gonna ask for a whole lot more than we really want. And so when you look at, we are paying a lot out in the settlements, but you look at your risk and you say, it's gonna cost a lot less than going all the way to due process.
Mm-hmm.
And that's where I see the problem. We're spending a lot of money for things that we shouldn't.
Which is a good point. Is even if it works, is it too expensive to do the job? Yeah.
As I sit here and look at all of this and listen to the discussion here, it's always working under the assumption that due process hearing is to resolve a dispute that arose in a case conference, well, we call them case conference committees in Indiana, an IEP meeting. But we have a few attorneys, parents' attorneys in Indiana that will file for a due process hearing. And there wasn't a dispute in a case conference committee meeting. They just say the school failed to offer free appropriate public education at any time during the past 2 years, because there's the 2-year statute of limitations. They're not saying we've got a dispute over this issue that occurred in the past 2 years, but they're saying that none of the IEPs in the past 2 years was appropriate. And I guess what I would like to see, if IDEA is revised, is to make the first piece of exhaustion of administrative remedies is that you first took your dispute to the case conference committee meeting, or the IEP meeting, and you don't just file out of the blue when the school had no knowledge that there was a dispute here at all.
To the you have to take it to the IEP team, which would be fine as long as your dispute actually involves the IEP. But if they deemed your child not eligible, then you wouldn't even have it. Yeah, right. Yeah. But yeah, I get your point.
But
right.
again, in Indiana,
although it sounds to me like your attorneys are not.
It's the money.
Well, that they might have a problem, you know, this sort of general no FAPE for the last 2 years, right? Oh, just wait, I want to get your comment and.
So I'm just wondering, so I'm from Washington State, and under our state regulations, we allow enforcement of resolution agreements through citizen complaint or state complaint. And I'm just wondering if you know any difference, because I understand some states don't do that. And so I could see where it would be, if I'm a parent and I agree to this resolution agreement, I might be more willing to agree to this knowing that I don't have to go back to court to get it enforced if I can just file a state complaint which doesn't require an attorney for me to spend any money. And I do the investigations, and we do find in parents' favor if the districts didn't do what they were supposed to do. I'm just wondering if that helps to get people to approach that process in a different way.
Something Hillary wants to talk.
This one I can say
something. Okay.
So while the IDEA allows parents to seek enforcement of due process decisions through the state complaint process, states still have an oversight responsibility. They have a general supervisory responsibility to ensure that those decisions are being implemented, even if a parent does not come to them and say it's not being implemented. So we would expect that states are ensuring that those decisions are being enforced regardless of whether there is a state complaint filed on the issue.
No, yeah, I mean, I understand that. I just think if parents kind of know that right away or up front, and they kind of understand it,
okay.
I just wonder if they'd be more willing to participate in that, knowing that they feel like they don't have to.
I think you raise a very important point.
Yeah. So our time is up. We had one more comment.
I was just going to say one of the things we talked about at the beginning of your presentation was about lack of access for folks that are low income, and this resolution session for a lot of individuals who, a lot of parents who have children with disabilities in the schools. I mean, the due process mechanism is not something they'd access anyway, much less this resolution session. And you know, I think the idea of having, you know, some neutral third party, whether it's a mediator, whether it's a facilitator, that would allow greater access for people of low income to have access to the rights. Because I think that we know that, you know, kids with, I mean, I think we all can probably accept that the kids with lower incomes probably are getting a different version of FAPE than kids with high income. And so we really need to be able to provide resources to those folks that they can access. And you know, due process is really not where it's at.
I agree. That's a good final comment. Well, thank you all very much. I really appreciate all your thoughts and comments, and thanks.